Yep. Good evening. Welcome to the Rental Restriction Overlay Districts in East Lansing informational meeting. Thank you for braving these temperatures to join us tonight for this information sharing. I am Robert Bellman, City Manager. Tonight we have several staff members to present and to hopefully share relevant information on overlay districts in East Lansing. First, I'd like to introduce Annette Irwin, who is Interim Director of Planning, Building, and Development Department. Prior to being promoted to that, she was the Housing University Relations Administrator for the City of East Lansing. To her right is Landon Bartley, who is the Principal Planner for East Lansing. And to my right is Tony Chubb, who is City Attorney. So we're going to share a lot of information throughout tonight's presentation. So we're going to talk about the history, implementation of 20 districts, where, what type, when created, do an overview of the ordinance, overlay types and requirements, procedures to establish a rental restriction overlay. We're also going to share information on rental housing licenses, the definitions, both in zoning and housing, and the types, exceptions, and then we're going to have a discussion, question, and answer. Now, you may want to share what-ifs or scenarios. We may not be able to help you on those what-ifs or scenarios because there's a lot of factual information we review when formal applications are submitted that we may not get tonight. So I don't want to disappoint you if you get up to share a what-if or a scenario that we may not be able to answer thoroughly tonight. But we did want to share a lot of information. So with that, the first up is Annette. And before I go, I'm sorry, there are handouts on the podium, as well as there was a QR code on the first slide that you could scan that will download this information to your phone, or you can access it on the city's website.
And Robert, if I can mention that the link and the QR code are also on the last page. If you do have a handout, they're on the last page of that handout, on the last slide. If there aren't any handouts left at the front, you'll have that chance later on to download the handout as well. So, thanks.
Okay, thank you. So if I talk too loud or too quiet, let me know. I have one ear plugged. It's a weird thing I'm trying to deal with, but as I just started to talk, I realized, oh, I'm echoing into my head. So thank you for coming out this evening on a really, really, really cold night to learn a little bit more about rental restriction overlay districts, rental licensing in the city, and exemptions from needing a rental license. Hoping you're all as excited about the topic as we all are. So I am going to start it off with a little bit of history about the overlay districts. And I think I'm chosen for history because I'm the little bit of the historic one here at the table, having been here for a bit of a tenure. So the overlay districts, and on your sheet, I think it's referred to as 1035C was the ordinance at the time. So Ordinance 1035 was the ordinance that introduced and then was adopted regarding rental restriction overlay districts. And I'm just going to give a short history because I think there's other meatier information everybody wants to hear about. But to give a little bit of short history and context. So rental licensing in the city has been in place since the mid-70s, early to mid-70s. No, I wasn't here then, but. We've been licensing rental properties since that time. And throughout the decades, there's been different ordinances in the zoning and in rental licensing that have been put in place to somewhat manage, I think, the amount of rental licenses in the city. So the reason this kind of came along is as we were issuing new rental licenses, so we refer to them as initial rental licenses through the Housing Commission, folks were coming and really asking the city council at that time, and at that time that is, April 2004 was when it was enacted. So 2003 probably is when this discussion started, I would say. about what else can we do? Are there any other tools in the toolbox? What can be done? And this was from the East Lansing residents. So at that point in time, the city council, working with the city attorney at that time, kind of went through, okay, what else can be done? Are there any other tools that can be put in the toolbox to empower our residents a little bit on this, where rental licenses are, and give them a little bit of control? And that's really how this came to be. So the ordinance does empower residents to be able to be a part of this process, really initiate the process, meet with their neighbors, fellow residents in an area, and then petition to have one of these rental restriction overlays. And we'll kind of get into later, I think we get into the different types and whatnot, right? So I won't go that deep in the weeds right now. But that's just a little bit of the history and why this came to be. Really intended as another tool in the toolbox to help residents who were interested in kind of stabilizing maybe an area in their neighborhood. And I say the term neighborhood loosely because I know, everyone's a part of a neighborhood association for the most part. So, and when we say neighborhood, we're not necessarily talking about your whole neighborhood association. So if you live in Glen Caron neighborhood, or you live in the White Hills neighborhood, or the Bailey neighborhood, and I'm only throwing those out there because they're larger areas. So when we say the overlay in the neighborhood, it's not necessarily that whole neighborhood area. It could be a portion of a neighborhood, which we'll kind of see as we go down the road here. But really, the reason this ordinance came to be was really to give residents a tool for residents who were interested in kind of stabilizing the rental licenses in a particular area. And the ordinance itself goes into a lot of detail about how many parcels that would be and what would the borders be, how do you make that decision, because you can't just, oh, this house, this house, this house, which you'll see as we move through this and share more information. But that's a bit of the history, kind of how this came to be, why it is there, and lots more to come. And I'll keep that part short. So we do have currently 20 overlay districts within the city. So there's 3 different colors here, as you'll see on the screen. RO1, RO2, and RO3. RO1 being, and so the pink, it's not to confuse the 2 pinks, by the way. So there's the city border on the outside. That's a pink. Yeah, maybe we should, just to be sure. Because at a quick glance, I'm like, whoa. So yeah, so city border. So no straight lines anywhere, right? Even the city border. So is a pinkish color. But one of the overlay districts, the RO3, is also a pinkish color. So that's the RO3, those smaller squigglies. So the RO1, the orange, is the most prevalent overlay district. It is also the most restrictive. And what that means is no more new rental licenses within a particular area. So inside of all those orange areas, an owner cannot apply for a rental license. So you can't utilize your home in a way that would require a rental license. And the residents in those areas petitioned to have the overlay, and they also, these were all over different periods of time, starting in 2004 through current. I'm going to skip down to the RO3. So we're going to skip over the RO2 for a minute. This is later, right? So RO2 is, you see is green. We have the fewest of those. And RO3, of course, would be next.
And then
after
the yellow is the one pending.
Oh, yeah. Thank you. Yellow is pending. We do have one rental restriction overlay ordinance pending. And lots of folks in the audience I recognize and know that. And that's the yellow, and that's kind of and that's in the Glen Caron area there.
It's the map of rentals.
Okay, so what do we have here? This is a current map of rentals in the downtown area. And if you go on the city's website, you can see this information. You can see it for the entire city. If you need help getting to it, walking us through, we're happy to do that. But this is kind of to give a snapshot of rentals in the downtown area. You see the Chesterfield neighborhood over there, in the far corner, I was gonna do the left-right thing, and we're all opposite of each other, yeah? So, and then Bailey is kind of that whole area there. There's a little bit of a void there in the middle, so the center of Bailey, commonly known as the Strathmore area. There is an overlay in the Strathmore area, and I will say that that part of Bailey historically, folks did not necessarily apply for rental licenses there. You know, the other area that was more commonly, and I think the Strathmore area during those years of the 70s, the 80s, and early 90s when we were having a lot of folks apply for rental licenses, that particular area, the market was such that I don't think it was as desirable. So, and then since then the overlay. So it just gives you an idea. So what do the colors mean? And I don't know, we can't really see the legend on here, but for the most part, like the most common you see are the light blue. So that's kind of a single family, typically rental license. And we'll get into all the different licenses and what they mean. That's the most common one. You can kind of tell the green, right, is the apartment buildings, kind of tell by the size there. So it gives you a sense of some of how many rentals do we have kind of in that inner downtown area. Types, yes. So what does all this mean? Let me catch up to you for just a minute here. RO1, RO2, and RO3. So the RO1, as I said, is most restrictive, no new rentals. So we kind of have our graphic there on the bottom, you know, no new rental licenses. If there is a property with a rental license currently within an overlay, that is a legal non-conforming use that can be maintained. So if I own a rental property within an overlay already, I can continue to renew that license and utilize that license and have that property right. As such can the next subsequent owner, if they also do what they need to do to keep it licensed and renew it. But no what we call initial rental licenses in RO1. Now I'm going to jump over to the RO3. I just think it's easier this way. So this is the least restrictive. So if the RO3 allows an owner's family to have a roomer. So an owner's family to have a roomer. And so what is an example maybe of that, just briefly to start off our conversation here, is so let's say that my husband's Ron, we'll just use real life, I just think it's much easier. So Ron and I own our home, and we would like to rent to someone to live in the home with us. So that means I would be applying for a Class 1 rental license, and then we would be able to have a tenant come and live with us in our home. So that is the RO3. It's the least restrictive, and there's you saw on the map, there's a fair amount of those. So what does it mean for RO2? That's also owner occupied. So the difference is, it is owner occupied, so Class 1 license for an owner and owner's family. However, only for the owners who owned the property at the time the overlay ordinance was passed. So let's just say where we live, there's an overlay district for an RO2, and it was passed in 2005, and we live there, so we could apply for a rental license. But let's say I sell my house to Landon, and he lives there now, and he says, well, I would like to apply for this rental license. He would not be able to do so. So it really, for a new owner, is kind of like an RO1 to them. So I hope that makes sense to folks.
That's still one person?
Class 1.
Class 1. One person, say more.
Yeah, okay. And you still have to get a license?
Right, nothing's changed. Yep, exactly. Yep. So it allows the owner and owner's family to have one roomer.
And that's, yeah, and so that's the definition of a family under our ordinance, which we'll get to in detail later as well.
Yes.
Not a family, but a roomer.
The family plus room.
Correct, okay.
Yes.
Okay, thanks. So we have three types of overlays, right? And RO1, RO2, RO3, and they all deal with Class 1 rental licenses. So an owner or owner's family plus one roomer, and that's the Class 1. If you're in the RO1, no Class 1, no new licenses at all. RO3, yes, but only Class 1. That's the only type of rental license. And then the RO2, like Annette said, she could do it, but if she sells her house to me, then I'm now not able to get a Class 1 rental license. But she was, because she was the owner when the ordinance was passed. So now let's talk a little bit about the requirements, and I'll get into the procedures as well in a moment. You might notice that these are very text-heavy slides, and that's not good practice for slideshows, but we also know that we're trying to make this information available, and we expect you're going to take these back as handouts. You can access these online, and you can take these back and have an easy access to the actual code language. So that's why we included the actual code language on these slides. So essentially, you have several steps as far as establishing a district and as far as how that district can be formed. That's all based on neighbors, right? So the residents of a neighborhood are the ones that lead this process. They say, we would like to circulate a petition, and at least 2 days before they start circulating, they have to go around and pass out a rental restriction overlay information sheet. And that's one of your handouts on the table. And that's also available online. So that's a 3-page sheet, and it just essentially lays out the kind of information that we're showing in this slideshow, hopefully user-friendly, and that you can read through it. And that way neighbors have a chance to read through this sheet and go, okay, what's going on, at least 2 days before they get the petition. We strongly suggest to petitioners that if you're going to do this, you also circulate a copy of your proposed map so that your neighbors are familiar with that map before they get the petition to sign a couple days later. But you're not required to. You are required to distribute the rental restriction overlay district information sheet before you petition. You have to identify which kind of overlay district you want. Do you want RO1, RO2, or RO3, as we just outlined? And then you must, the person who's actually circulating the petitions must live in the neighborhood at one of the properties that's contained within the proposed overlay district. You have to get the signature of at least 2/3 of the property owners of all the parcels within that district. So Annette made the distinction between a neighborhood and a overlay district boundaries. You know, an overlay district could be a part of a larger neighborhood. It could include more than one neighborhood association, but we typically see them just being a part of a single neighborhood. So as long as you have 2/3 of the signatures of the parcel owners of that district that you're proposing, those properties, then your petition would be considered ready to go towards the city council. Yeah.
That on 2/3 fraction, how close does it have to be? Like, what if you're like 2 people off?
Then we come back. So the question was, hey, how close is this? How much is 2/3? And if you're 2 people off, is that okay? Nope. We had a pending case that was 149 properties. We required 100, and if they came back with 99, we'd say, sorry, you're not there. You got to go back to 100. So we take that pretty seriously. Yep.
I have a similar question. What is the city's procedure for people who realize they didn't really want to sign the petition, have their name removed?
We will. We'll get to that in a second. So so as far as signing the petition, you've received the rental restriction overlay information sheet. Hopefully you've received a map, but you're definitely going to get that petition with the language and all the description of what's proposed. The boundaries will be on that petition. The type of district that's proposed will be in that petition. So hopefully you'll have enough information that you feel like you can make an informed choice. We have had cases recently where we've had petitions come in and there were concerns and there was confusion at the time, and some signers said we'd like to get our signatures taken off that, and they can do that on a case-by-case basis with the city clerk. We just have to. It just presents some complications because at some point, once that petition's in and all the signatures are counted up and found to be valid, at that point we got to close the door and say, okay, we now have what we consider a valid petition. So and I'm going to take a few more questions in a moment, but I want to get through the requirements. So the petition must say, here's what restrictions are on that property through what kind of district we're proposing. The signer would sign off saying that, yes, I got this information sheet, I received it. We're trying to confirm essentially that the person who's signing the petition understands what they're signing. And like I said, if not, for some reason, we have a little bit of a window where you can come in on a case-by-case basis and talk to the city clerk and say, hey, I didn't mean to sign. But that's quite limited. The petition will actually describe the boundaries of the proposed overlay district, and within that, the boundaries, there must be at least 50 different parcels. So that's one thing that I wanted to mention too. I mentioned 149, that's an example that came through recently, but as long as the petitioners have at least 50 parcels within the district that they're proposing, they're good to keep going, but they have to get 2/3 of whatever number they choose of parcels within the district. They have to get 2/3 in order for their petition to move forward. The proposed boundaries, in addition to the 50 separate lots or parcels, the boundaries must be within entirely of properties within the R1, R2, or RM8. These are residential zoning districts. Within those districts, and they must be contiguous. So you're not going to have commercial properties in here. You're not going to have them split in pieces across an area. It's going to be one contiguous area, all with residential zoning, R1, R2, or RM8. And the boundaries can't overlap an existing rental restriction overlay district if there's one adjacent. And then finally, your signatures are good for 6 months, because at some point, again, we got to close the door and say, look, this has been going on for a long time. You got to complete your signatures and get your petition in within 6 months of starting it. So that was a lot of text, a lot of information, but those are sort of based on, that describes what the requirements are for the overlay district. Yes, in the back, please.
One question, what happens if you did not receive the district requirements, did not receive a petition to sign, and yet you would have liked to be included, and most of your streets included, your house is excluded?
Yeah. So.
What recourse do we have?
So the boundaries of a district are up to the petitioners, and so they're proposing a certain area, a certain type of district with certain boundaries, and they have to submit that map for the city to validate and make sure that it meets these requirements. And through our review, through the Planning and Zoning Department, through our city attorney, and we can talk more about that in detail. We look at that map and determine, does this meet the requirements? And if it does, great, we'll move ahead. And if it doesn't, then we'll reject it and say, here were the problems with your boundaries. Please correct them and come up with a new map.
Okay, I guess
Yeah, Landon.
we live in a house on Oxford Road, across the street, they're
Yep.
all covered, they all did receive petitions to sign. We are on the south side of Oxford, there's one block, there was
Yep.
co-excluded, we were not given any information or a chance to sign the petition. We certainly would have. We've been in that house over 45 years. We've raised our kids there.
Yep.
We are a central part of that community, and we are not being given a chance to be involved in this overlay.
Yeah, so as it
That is
relates,
not- that
all right, sir, I can.
Totally unfair, and maybe, I don't know, a civil question.
Yeah, so the way that the ordinance is drafted, it's very clear that the boundaries of the district, first of all, they're created by the resident that's circulating them, and they have to be subject to the ordinance, which says that the boundaries must consist of streets, alleys, platted subdivision boundaries, and existing zoning districts. So there's no circumstance where individual homes can be handpicked to form an outline that would not be contiguous with the zoning district lines, the neighborhood district lines, or the street lines. And so the vast majority of the time, likely, and since Landon and I have been reviewing applications, that has been the basis for rejection of proposed maps, because they do seem to try to handpick to include or handpick to exempt certain properties, and that's not the way that the ordinance is written. But as it relates to,
Excuse me, sir, can
Sir.
you let him finish his explanation, please? Thank
so there's never going to be a circumstance where one home on the north side of a street would be included and one would be excluded, for example. As it goes back to the, sir.
Included in the south side not, and none of us were given a chance to sign or even
I might be able to help a little.
And that's,
My rights for being protected.
sure, and that's the process for initiating the overlay districts. Is the proposed map is by the person circulating them. And so there's no right that's being created by the city council. Likewise, there's never going to be an overlay imposed by the city or the city council without the initiation of residents within that zoning district. I also wanted to talk about, as we related to requests to be removed, and I think Landon explained it, the process is that we can review requests to be removed from a petition prior to the petition being submitted. The process that Landon described is a very complex process of review. We typically do have petitions submitted with the bare minimum of signatures, and so once they go in for review, the clerk determines if there's a sufficient number of signatures, along with the assessor, who determines that they're proper signatures and that they're the property owner. And then it goes to Landon and myself as the city attorney for review. And if people continued to request to be excluded from the count after the process was in review, or we likewise had a circumstance of someone that requested to be excluded and then subsequently requested to be added back in, the administrative process it creates tremendous turmoil. So the process that we use is that we will continue to remove until such time as the actual application is submitted.
So just let me add this. We're going to hold on questions because some of your questions may get answered in future slides in the information we're going to share. But going back to the point, sir, about your desire to want to be added to this overlay district is you need to attend the public hearings, share that information through the Planning Commission and the City Council, and then the City Council ultimately has the ability to change the boundaries that have been submitted to them. So if you want to be added, there's the process. And I want them to explain the process that may be able to answer your question before we get into the depths of further questions. We may already answer them through the information you have in this PowerPoint presentation.
In your clarification, for example, I understand there was a first map that was submitted and then withdrawn or redrawn by the lawyer. That first map did include us and some other houses, but for some reason it was not accepted, it was changed. So in your explanation, I'm hoping you're going to explain why you did that. Because there was another boundary petition given that was then decided by somebody to redraw. So you need to explain to your citizens here why that was done, under what authority.
And I'm going to need to stop real quick as far as individual scenarios where it's going to be hard to cover those, and like Robert said, we should save questions until the end. But the boundaries are drawn and proposed by citizens. They're vetted through the city process, and like Robert said, there is a process and the ability of the city council to reconsider those boundaries if those are needed, and if that's found through the public process. Because sometimes people are going to say, I wanted to be in this district and I didn't even know about it. And others people are going to say, I got into this district and I didn't want to be in it. So that's why we have public hearings. That's why we have informational meetings like this, or like for pending cases in Glencairn, for example, so that we can hear that kind of feedback and try to make sure that that's conveyed to the Planning Commission and the City Commission. So I know that the requirements up here is a lot of text. I wanted to go through a little bit about the procedures. For those of you like me who are a little more visually oriented, let's just sort of go through this little flow chart to talk about how this is established. So you can see the step one is that neighbors say, we would like to establish a residential overlay district, a residential rental restriction overlay district. And at that point we say, we strongly suggest, if you want to do this, get your neighbors together and have your own public hearing, before you get to the city process, so that you can try to understand your neighbors' concerns or their level of interest and move forward from there. The next step is meet with planning and zoning staff, which is right now myself. We'll have some more planners to meet with at some point soon, but for right now you just call up the planning department and say, hey Landon, I'd love to talk with you. A couple of neighbors of mine and I are interested in proposing a residential restriction overlay district. Let's talk. So then you draw up a map that we check against code requirements, and then we make sure that if it's okay, we return it and say, go forth and petition. And if it's not, for whatever reason, like Tony mentioned, it doesn't meet the boundaries being of streets, of zone district lines, of platted subdivision boundaries, whatever it might be. So we'll return that map if we need to. We go back and forth and make sure that what you're moving forward with is a map that meets the requirements of the ordinance. So that's step 4. Let's say that it does. Then you go out and you distribute your rental restriction overlay information sheet. Again, that 3-page stapled sheet that's one of your handouts. At least 2 days before your folks are going to go out and circulate petitions. And you make sure that you specify what type of rental restriction overlay you're doing. And we also strongly recommend, like I mentioned, that you circulate a map so that people that you're talking to understand the proposed boundaries. The petition language has the boundaries, but sometimes, again, it's hard for me to look at words and go, okay, I think I understand where this is. So we strongly suggest that you also circulate a map when you go around with the neighborhood to circulate petitions. So you're circulating petitions now in step 6, and again, you need to find at least 2/3 of those property owners for all the parcels within your proposed boundaries. Once you have enough signatures, at least 2/3, you turn them in for validation, and what we do is make sure that they're accurate, they're actually owners, there are a couple sort of things we look for, and make sure that basically the signatures are valid, right? So then we count them up and make sure the signatures we have enough valid signatures, 2/3 of the area, to move ahead. When that's the case, we will draft an ordinance on the city side that says essentially the ordinance version of what you're proposing in the district, and that will go to City Council. City Council introduces and refers the ordinance to the Planning Commission in their consent agenda at a meeting. When City Council introduces the ordinance, and that's just saying we're introducing the ordinance, we're putting it onto the table here for discussion by the Planning Commission. But when that happens, now that district is pending, right? It's in process. We found out that the boundaries meet the requirements, the signatures are valid. Now we're ready to take action potentially and start that public hearing process to make sure that people's concerns are being heard. What's really important about that is now that it's pending, an automatic moratorium goes into place, a moratorium on any initial new rental licenses within that district. Because it's pending, sometimes that's a key for somebody who's going, oh my gosh, this is happening. I should rush in and get all my rental licenses right now. We don't want that to happen, right? Because the ordinance is pending for a reason. It's here for a reason, and so we say, okay, let's stop the process right now as far as new rental licenses, and let's get this proposed rental restriction overlay district through the process. So then it goes to the Planning Commission for a public hearing, where you can tell the Planning Commission how you feel. I see a couple Planning commissioners in here tonight. Thank you for being here. The Planning Commission is going to listen very intently to your concerns. They want to know, is this the right type of district? Are these the right boundaries? Are people getting included that don't want to be included? Are people getting excluded that really want to be in this district? What are the pros and cons? They consider that over a public hearing. They come back. They listen to your comments again. They have discussion a couple weeks after that public hearing and make a determination. Do we want to recommend approval or denial by the City Council? So then they pass that recommendation on. The City Council has their own public hearing where you have another chance to let them know, hey guys, I told the Planning Commission this. I really want you to know, City Council. So you tell them how you feel about the proposed district, and then City Council at that point will make a final determination on whether or not to approve or deny the ordinance. Like we mentioned, City Council has some leeway, and we'll get into a detailed ordinance description of that in just a moment. But they have some leeway to adjust the boundaries of the type of the district that's ultimately approved or not. So here we go with the ordinance review, right? I really want to focus in on, let's focus in, Tony, if you can go into section 2E on this one, talking about the City Council's sort of power once it gets through the process to the City Council, what can they do with the ordinance that's proposed?
Sure, absolutely, yes. So because this is a part of our zoning code under the Zoning Enabling Act, that's why it's required to go to the Planning Commission after our administrative process, and likewise the council, after they have the recommendation or recommendations of the Planning Commission, can make changes. And so as it relates to the overlays, that does include the ability to modify the boundaries as originally proposed, including enlarging it or decreasing the size, so long as the decreased, I'm sorry, yeah, so they can increase or decrease it so long as it doesn't result in spot zoning.
Correct. And spot zoning, if you're not familiar with that, is just essentially saying, hey, we're going to change the zoning of just one parcel or a very small spot, and that's not allowed by state law. So that's
Correct.
why the city council, in part, has that authority to add or remove properties from the district. So that's really focused on the council authority at the time of their decision. Let's look on. Oh, we should also talk about number 3 a little bit, because that's a little bit confusing sometimes. Essentially, when you have, let's say that the ordinance has been introduced at the council, and then the circulator of the original petition says, you know what, or a majority of the people who signed. So let's say that a bunch of people in the neighborhood said, you know, I signed, but I'm not so sure I am still in favor of this ordinance as it's presented. So the circulator or a majority of the signers can say, you know what, City Council, would you table this for at least 60 days so that we can submit an alternate petition? Something different, a different kind of, different type of ordinance or a different type of restriction or overlay. So let's say it's RRO1, and you say, I'm not so sure about RRO1. We actually want RRO3, and a majority of the folks who signed it said we want RRO3. Then at that point, you can sort of stop the process and say we'd like to restart the process as long as it's within 60 days of introduction. So that's just a wrinkle that I want to make sure is covered, a little nuance of the ordinance that could be important, or the original circulator can bring that up. I don't know if you want to mention anything else, Tony.
No, I think that's exactly right, and it's just important, just like you said, to understand it's limited to the circulator or the majority of the signers. It doesn't allow for dueling circulated petitions from different individuals.
Right. But there can be. So just because an ordinance is introduced by the council doesn't mean that another ordinance can't be brought forward. A competing ordinance could happen as long as it gets through the same process. That might just inform the city council's discussion or the planning commission's discussion, though. And they might say, okay, well, we know that there's something else going on in this neighborhood. We want to see what's happening or what the concern is. And that would be considered sort of a separate process. It wouldn't do anything to stop the first process from going on, but it might inform the discussion if that's of help. We good to keep going, or do you want to take any questions before we talk about rental licenses? I guess to your point, we might cover the
sorry.
answers.
Go
So
through everything and
we'll keep
then-
on.
right.
We'll keep waiting on questions real quick, but keep those in your mind, write them down, and we'll make sure to get to them at the end. So now we'd like to talk about some specific definitions that are very pertinent within the housing code or the zoning ordinance. And we'll start with the definition of family. And was this yours?
Sure, I can, yep.
Sure.
So definition of family is in the zoning code. And we've kind of laid out here, again, as Landon said, there's text for this also. We've kind of did the visual here of what is the definition of family. So one person, two or more related persons, or two unrelated persons. So Landon and I, if we are sharing a home, we are considered family under the zoning code because two unrelated persons.
We're acting like a family.
Yes.
We're running the house together. I have to clean my dishes. We're doing what we should do as roommates.
So I think that distinction will be important later as we work through some of this. So I just wanted to kind of point that out. And then related persons, who does that include? And I always say it's kind of what you would think in many ways, spouse, child, parent, aunt, uncle, stepchildren, adopted children, siblings, grandparents, grandchild. And also in the case of rental licensing, there's a little nuance there, that nieces and nephews. That is not in the definition in the zoning code, I think for some various reasons, but in the housing code, it does say nieces and nephews. So they are considered my family. for rental licensing purposes, which will make sense as we move through this, I believe. Or a domestic unit as defined in the code. So, and we do have the text there. So beyond the visual, there's more text. So for those who want to see the detail, of course, and it makes a difference, is to read through that and see what all that definition is. So domestic unit is also considered to have the same rights and as a family would. So what is a domestic unit? And we kind of list that out here, domestic unit, and I will read a little bit of this because I think it helps, and not everybody, I don't think, probably can see this. Domestic unit is given the same rights and privileges that shall the same duties and responsibilities as a family. So in this case, so the domestic unit is a collective number of individuals living together in one dwelling whose relationship is of a regular and permanent nature and having distinct domestic character or a demonstrable and recognizable bond where each party is responsible for basic material needs of the other and are living and cooking as a single housekeeping unit. So, and I think it's kind of important to think about some of those words there. It's kind of a permanent bond, responsible for each other, acting in the same way as a family. And what does it not include? It doesn't include a society, club, fraternity, sorority, association, etc. Because sometimes we'll have folks will say, you know, it's my sorority sister, we're super close, we do all this, you know. That is not definition of domestic unit in the same context of family. So that is kind of highlighted there.
Or the group of individuals whose association is temporary or seasonal in nature, right? And it specifically calls out, or for the limited duration of their education. So you have a couple students, they're probably not going to be a domestic unit unless they're, for example, in a long-term relationship where they act like a family.
Yeah. So some people will say, well, that's my very best friend, but you're not family, you know. And so there's a difference there. You know, my very best friend, I don't hold in the same responsibility as I do necessarily a family member that I live with. So there is a bit of a nuance there. So we wanted to point that out. So that is something that, you know, folks can come in, talk to Landon about that, kind of explain it further if need be. We don't have it come up very often. I have seen it in a few cases. So that is there to give people the same rights as a family.
Should we keep talking about definitions? Let's move on to dwelling.
So then continuing on, so dwelling, we do have some depth because we've had questions about what does that mean. It's a house, a building, a structure, occupied as a home, residence, I think all the things you think about. A dwelling unit, so that can be dwelling unit, there can be more than one unit in a building. So there kind of explains that, right?
A group of rooms that forms a single habitable unit.
So we have, so kind of for our purposes, we have one family dwelling, two family dwelling, multiple family dwelling. And it kind of explains some of the different definitions there and what those mean. In the Class A and the Class B, multiple dwellings, it's out of the zoning code, and it's just to kind of show the difference in group living. So, in Landon and or Tony will correct me with more legal terms if need be, but I think for what we're all thinking about, so a Class A, you know, what is an example of that is going to be what we think of most commonly are apartments. So that's a Class A multiple dwelling. And what is a Class B? And I think, again, examples work well. Class B is kind of what you think of as those maybe larger group living homes. So an example are some of the traditional large fraternity house, sorority house, a co-op, Evans Scholars. We have some religious organizations that have group housing together here in town. And it doesn't have to be, I'm giving examples that we think of as kind of student related, but it does not have to be a student group. So it's just a group of people living together in that way, but most commonly in what we see in our community, and that's why we give them as examples, are things like the fraternities, sororities, organizations, all living together in one large dwelling unit.
And generally, a difference is that Class A has, each unit has its own kitchen or cooking facilities, and in Class B, it does not.
Right, they'll have their own rooms, or they might have, room they share, but everyone then shares together their cooking facility in the building.
Should move on to other terms. When we start talking about licenses in a moment, we're going to start talking about exceptions. And there are a couple terms that you'll need to know about in those exceptions, such as childcare, guest, owner versus tenant. Do you want to talk about, I guess, childcare and guests?
Yeah, childcare. So as Landon said, as we look at rental licensing and when do you need a license and are there any exceptions to a license? Yes, there are. There's 7, I think, is the official number of exceptions. And some of them do have a little bit more of a definition, and one is childcare. So this is a person who provides childcare, and they devote at least 20 scheduled hours per week, at least 42 weeks per year, supervision and care of a person, living in the home, and you guys can read the rest under 14. Someone might say, well, why is that so specific? Everything happens for a reason. So this is specific because we had some cases come up where we had gotten a complaint, and when we went out to follow up, the owner said, yes, this is a person I have living here that has does child care for me, but the home didn't have, I guess, what you would think of as a traditional need. This might have been an older high school student that was living there, but the child care was a college student that was living with them to give rides to the high school student when they needed. So it really wasn't falling under the child care exemption. So for that reason, because of some cases, then we had to get a little bit more specific with what is child care. So that's why we have a definition here. Guest, who's a guest? And this does come up. So we do define guests. Can I have a guest in my home? Of course you can have a guest in your home. You can have more than one guest in your home. The city doesn't get involved. And so we had to define guest, how long? And of course for a reason, because things that have happened in the past. So we do define guest. A guest is someone who's staying in your home for 30 consecutive days or less, or 60 days within a year. So, if I have someone staying with me, I don't know, for the summer, there's been some scenarios brought up, but let's say that I have someone coming to visit me in the summer at my house here, and I happen to have another house, so I'm going to go to that house up north, and as the guest is at my house, but then they come and see me at my house up north because it's really hot down here and it's, more water up there, whatever the reasons are, to get away. So they've now left the home here, so that now they've broken that 30 consecutive days. So something to think about, right? Because they've left for a period of time. So then perhaps they could come back again, right? Because now that we're talking about any 60 days in that year. So I just kind of wanted to point that out.
Your license types.
And I think that's do we have any other definitions here, Landon, that you specifically think we need to speak to?
Occupy owner now. I think we could probably move on to the license types.
Right. Oh, license types, okay. So we have 6 different kinds of rental licenses in the city. And some of them are legal non-conforming rental licenses. For the most part, you don't apply for those any longer. A resident wouldn't be able to apply for those any longer because of the zoning changes throughout the years. So I'm going to break these down. And looking at the first 2, those are both owner-occupied type licenses, a Class 1 and a Class 2. And we've talked a little bit about a Class 1 rental license. That is the case where, my family and I can apply for a Class 1 license to have a roomer live with us, one roomer, live with me and my family. So the Class 2 rental license is specific in that it is also owner-occupied and allows the owner and owner's family to have 2 or more roomers. And it is specific. The rental license will say 2 roomers or 3 roomers. It's either going to say 2 or 3. That's all there is. There's not more. But those are legal non-conforming rental licenses. Those are not issued any longer. The zoning code changed in November, I believe, of 1987. And some of you who have been in the city for a while may be familiar with an ordinance called Ordinance 900. It's kind of big news at the time. So Ordinance 900 at the time was what changed the zoning code so that you could not apply for those types of licenses, the Class 2, and I'll get to it, the Class 4. Those are legal non-conforming, cannot apply for those anymore. So when someone applies for a rental license now and they come before the Housing Commission, it goes to City Council, they are either applying for a Class 1 or a Class 3. Class 1 or Class 3. And we're talking about in the neighborhoods, in residential neighborhoods. So R1, R2, R3 is the zoning district. So we're not talking about apartments or the city's new construction on developments or anything like that. This is just basically what we think of traditionally as neighborhood residents. So Class 1 is the owner occupied. You can apply for those as long as you're not in an overlay district, meet all the other criteria, and that allows the owner and owner's family to have 1 roomer. Can no longer apply for a Class 2 rental license. Yes, they are out there off the top of my head, and I didn't look up the numbers, and I really wanted to have numbers for you all tonight. We'll still get that. We'll get that posted. But, you know, there's maybe 9 in the city. So Class 3, that is the other current rental license owners can apply for. Class 3 is non-owner occupied, allows for up to 2 unrelated persons or a family.
We have it as owner occupied. That's a mistake.
Oh, that's a oops. Not owner occupied. Can an owner live there? Sure, but it doesn't get you anything. So the intent of a Class 3 is non-owner occupied, and that allows for up to 2 unrelated persons or that two-letter word is really important, or a family to live there. Not and, just or. And we often have to kind of really specify that.
So just to clarify, that was my mistake. Class 3 should read non-owner occupied. Just missed that.
And we'll correct
Just
that.
want to make sure, so you can all write that on your pages.
Could you clarify you said for a maximum of 4 if,
Are we allowed to shadow questions? Is that what
Not at this time. Let's wait. Write that down,
We
please,
can
and
go
just
for the
draw us back to that.
specific discussions too.
So Class 4 rental license, what is that? So we'll go to the next one, right? So after Class 3, there was Class 4. Class 4 is, again, a legal non-conforming rental license. An owner, I think this is rare up there because, you know, there's an exception every once in a while. For most part, an owner can no longer apply for a Class 4 rental license. That is the most common rental license in the city. So that is a non-owner occupied rental license. See, if we keep talking, we get the answer. I saw him go, okay. So that is a non-owner occupied rental license, or that's the intent. Doesn't mean that I as an owner can't just go live there and not utilize that license, but the intent is non-owner occupied, and that's going to be 3 or more unrelated persons. And the rental license will specify. You'll have a rental license for 3, or a rental license for 4, or a rental license for 5 unrelated persons. So that's a Class 4 rental license. It's legal non-conforming. As an owner, you cannot apply for that license anymore in our residential neighborhoods. It does say rare up there, because if you just happen, if there's any out there anymore, and I'm not sure there is, to have a single-family home in an area in the city that is zoned multifamily, let's say RM32, and you own a single-family residence, you may be able to apply for that Class 4. I'm going to say may, because again, there's specifics to it. You have to meet all the zoning criteria, the setbacks, et cetera. Super rare.
And so just to clarify, we wrote rare because it's rare that you'll have any new ones. Very rare to have any new ones, but it's a very common current license type out there. You just don't see any new ones now.
Right, exactly. So someone will say, my neighbor has one. Yep, they do. They probably got it, you know, they clearly got it before 1997. And it's been maintained. So Class 5, okay, so we'll go quick there, apartments, kind of makes sense, right? So those are, Class 5s is how we license our apartments. Those go through the planning commission, the city council, lots of public hearings to develop a new apartment building in the city. That does not go to the housing commission.
And the Class A multifamily dwellings are Class
Correct.
5 rentals?
Yes.
Class B are Class 6, right?
Yes.
Okay.
Yep, you got it. So Class C, making that up. Class 6 rental license is what we were talking about earlier, kind of a rooming house example. So, and there's a fair amount of those out there. Off the top of my head, approximately 200, approximately. So that's the Class 6. And we don't see many of those new either. And if we were to see a new one, again, that's going to be a case where it goes through the Planning Commission and the Housing Commission. A lot of public hearings and a lot of public notice.
Should we talk about exceptions?
Exceptions,
Let's talk
yes.
about
There's an
exceptions.
exception to everything.
Before we get there, I just wanted to make sure everyone understands, when we talk about legal nonconforming uses, we use that term a lot, and we want to explain it. They're not available currently because the ordinance has been amended so that new ones cannot be applied for.
Right.
However, the way that a zoning ordinance is written, if you already have been granted the initial permit, then you can continue to renew it even though the ordinance allowing for those initial licenses has been repealed or modified so that they're unavailable. We want to explain them because, like Annette said, your neighbor may have one and you wonder why you can't get one. That would be why. It's because it was legal when they applied for it. The law was then changed, but they continued to renew that license that they had prior to the amendment of the ordinance.
Thank you for clarifying.
Yes, great.
So illegal means that you're doing something against the ordinance, and non-conforming means that the ordinance changed.
Correct.
And it was legal at the time. So, okay. Exceptions.
Some people call that grandfathering, but we just
Grandfathering.
don't like that. We like legal nonconforming. What's up with the grandfather? So, rental license exceptions, there's exceptions. One being family. Most common exception used out there is family. So I own my home. I don't live there. My children can live there. My parents can live there. All that we talked about in the definition of family, they can all live there. My nieces and nephews can live there. My family only. So as an owner, so if my husband and I own it, my husband and I's family can live there. House sitting, so that's the next most common exemption, I would say, and we don't have a lot of those at any given time, but we do get them. So house sitting allows for an owner who's owned and occupied their home. I am sorry, I am okay, and I'm not contagious. It's been confirmed multiple times. So, house sitting does allow for a owner to temporarily leave their home. Temporarily is the key, temporarily leave their home. So let's say I own my home and we're gonna fantasize here. The city wants me to go to Hawaii and explain all this to them at the island. Doesn't that sound grand? So I do, and because it's so far away, I'm gonna be gone for longer than, a few weeks. In fact, I'm gonna take a leave of absence and spend a year helping the folks in Kona do this. So,
I'll take next year.
yeah, this is how we have fun at work. So then that means that I would not apply. I would fill out the form for a house sitting exemption. So I could have up to 2 unrelated persons or a family come stay at my home while Ron and I are off doing our work. So we want to come back. We fully intend to come back to our home. We are temporarily leaving our home, and we're going to have house sitters there. The city does not get involved in, are you charging rent? Are you not charging rent? Are they paying utilities? Are they remodeling your home for you while you're gone? That sounds great too. That is not a part of this in any way. And the owner fills out a form. We have that on our website. We should have attached a copy, but we'll get a hyperlink or something on there. So you'll see the form. You fill out a form. You need to have it notarized. What we do when we intake it is confirm that you're the owner. So we're going to check our assessing records, make sure you're the owner. I might ask, so where are you going and when are you coming back? And then we'll send you a letter confirming, right? We'll send you a letter confirming. We have this form on file. So if something happens while I'm off in Hawaii and there's a snowstorm and everything freezes and I didn't, you know, my people that are there, something happens, I don't know, window breaks, water pipes freeze, then the city can contact the owners and say, okay, something's going on. You need to get a hold of folks who are supposed to be living there, et cetera. So we will have on file who is there, we'll have on file where the owner is so that we can get a hold of them. And in that case too, if a neighbor calls and says, I think my next door neighbor's renting, and we look it up and go, oh, temporary absence, they're, you know, house sitting, they'll be back. And that is for up to 2 years within a 5-year period. So you can come and go a little bit with this one too, but you have to own and occupy your home. You have to intend to return. Temporary occupancy by an owner after the residence is sold. So this happens, right? I sell my house, but we're doing the whole, I got to go to the next place, but it's not ready yet. So, you know, I'm renting it from the new owner I can do that for up to 90 days. And that's, city doesn't need to know, we don't get involved, that's an exception. So that allows you to stay there and rent from the owner until you get everything figured out there. Exchange students, visiting clergy, medical caregiver, child care. So those are also exceptions from needing a rental license. You know, exchange students, and if you read the ordinance, it'll say a recognized exchange student program, verbiage similar to that, I believe. And that is to confirm, again, this is an exchange student program. This isn't just happen to be an international student studying at MSU. It's an exchange student program. Kind of commonly high school, you hear about them. And medical caregiver and child care. So if I need to have medical care in my home, that's an exception from needing a rental license. Occupancy by an estate representative, that is a little bit more language in our definition there too, but you can have an estate representative, of course, stay there, doesn't require a rental license, and there's a period of time, I think that's also 2 years. Domestic servant, I don't know if that's ever used, but it does allow, and there is verbiage that explains that further. It has to be someone in your employ. So I've employed someone to work at my home, live in my home, and there is a little bit of verbiage that clarifies that. In religious occupancy, so if a church owns a home and they want to have that for the pastor, they want to have that for someone who works at the church, then that is an exemption from needing a rental license. So those are the 7 exemptions from needing a license.
Do you want to go into any more specific detail?
I think we're good. There's a lot of text
There's a
there.
lot of text.
I don't want to put everyone to sleep,
Yeah.
and I'm betting there's questions.
And
when
it's
we're
been an
finished.
hour, so I think it's time for questions.
Oh, and we are at questions.
Yeah. Finally, right? Time for questions
That's right.
and more discussion.
There you go.
So I guess let's
I was going to say let Robert.
let's go around. I know we had, sorry, Robert.
Yeah,
You were the
Robert,
manager.
Alice, you want to?
Yeah, Alice Traeger, 621 Sunset, part of the Oakwood neighborhood right there. I have to say, after listening to this, it's somewhat creepy to hear about the way the city ends up defining who counts as what in our lives. For example, it's odd to me that visiting clergy are allowed without a rental license, but not visiting scientists. But leaving that aside, so I think people often think that if rental licenses are suddenly allowed in a neighborhood, that what will happen is it will make it more available to renters who are families, et cetera. In Oakwood, I just want you to understand that the students actually control the economics of our neighborhood if there's not a rental overlay, and houses have become extremely expensive because they're worth a lot of money. And as a consequence, the rental overlay in Oakwood has depressed purchase prices, and it's allowed families who otherwise couldn't afford to live in our neighborhood to afford to buy houses. So it's been critically important for our neighborhood in terms of maintaining economic diversity, ethnic, racial diversity, age diversity, and bringing kids into our school district. Because families that could not possibly compete with big landlords or small landlords are able to purchase because houses are restricted and are not rented. So I just wanted to point that out. It's not true in every neighborhood, but you should think carefully about the economics of your neighborhood before you take risks. I just had 2 quick questions. 2010. It does require getting the percentage of signatures in the whole district, not just the expansion part. But there is a possibility to come back and expand by one street. We expanded by 2 streets. And secondly, I was curious to know, can city council enact a district larger than what was on the petition without first giving proper notice to the people whose properties are being added in by city council? In other words, does it have to go back to the planning commission after those people are properly noticed? Because I would think it'd be a little strange if at the last minute city council decides to make a bigger district than was on the petition, but the people in those houses never got noticed properly prior to the planning commission discussion and the city council discussion.
Sure, Dr. Drager. So your first understanding about expansion of a district by the residents is accurate. As it relates to the potential expansion or reduction of the district, the Planning Commission review encompasses consideration of making the area both larger and smaller. And so it's our interpretation that as a result, that's within the because it's already been reviewed by the Planning Commission, that it's therefore within the purview of the City Council to amend to include a larger district without it requiring going back to the Planning Commission prior to enactment.
All right. So I'm going to start asking that you come to the podium, sorry, Dr. Drager, but if you would. And that way we can hear it's being recorded and broadcast so that anybody else watching this meeting can also hear the questions.
Hello. I live in an overlay district, and I am mystified as to who I contact. As you mentioned, people have scenarios. I have lots of scenarios of people who could stay with me in my house, and I have no idea how to verify if that's legal or not. So if you could tell me who I contact with my scenarios, that would be super helpful.
Landon or I?
So on the PowerPoint, there's contact information for both Landon Bartley and Annette Irwin. So you can call or email and share your scenarios.
Or at least our names and titles. But Landon Bartley, Annette Irwin, we're the ones you should contact in that case.
Hello, my name is Samuel, local resident, also on the Housing Commission here. A couple questions. The first one is, in regards to the City Council making changes or recommendations, can they go from an R1 restriction to an R2 or 3 in their final decision? I know that you mentioned that they can expand, but my first question is that.
Yeah, that's a good question. I don't think we've ever dealt with that, but I don't believe that would be within their purview without the required signatures from the residents seeking that particular RO1, RO2, or RO3 designation.
Okay, and then in terms of expanding the map or the district, the proposed, what's their limitations in terms of how much they can expand or how little can they do that? And I think you mentioned that they wouldn't need new signatures to make that, and possibly might not need new notification, but what's their limitations on that, expanding or contracting?
Sure, and so of course I don't want to get too deep into legal analysis because this is a very complex ordinance, but there is a requirement that the 2/3, under subsection 2, subsection E, they can adopt an alternative ordinance in conformity with the changes, whether or not the 2/3 majority requirement of property owners would still be in that, or would still, that requirement would still be met. The reference signatures, though, go back to the initial application that's started by the residents.
Oh, okay, just to understand, if the example they gave, if 150, it has to still expand or to contract to that 2/3, the 100 signatures. So if it can't expand more than 150 households because there's only 100 signatures. That's what I'm understanding from you.
No, they can expand whether or not that's being matched. If they make it smaller, the owners of at least 2/3 of the parcels remaining in the reduced overlay district must have signed the original petition.
But when they expand, they don't need to get extra signatures.
That's correct.
Okay, and then my last is more of a statement. All current licenses, rental licenses, transfer on point of sale, except for R2 or Class 1 licenses that are in R2, Class 1 owner-occupied rental licenses that are in an R2 overlay. But except from those, all licenses transfer over at point of sale.
So rental licenses, most are transferable. So the only rental license that is not transferable upon sale is some of the Class 1 rental licenses. And this is irregardless of an overlay. Doesn't matter. So we're not talking necessarily about an overlay at all with that question. It is just, can we transfer that license to a new owner? You can in almost all cases. The only time you cannot transfer it, and it will be on the license, is a Class 1 rental license that has been issued, and I didn't write down the month, but it's after 2007. So there was an ordinance change by City Council during that time that Class 1 rental licenses were not transferable to a new owner. We only have a handful of them in the city, and that is designated right on the rental license. So those owners, irregardless if they're in any kind of overlay or not, when they sell the property right to rent that property, does not transfer to the new owner. And that will be on the license. So everybody knows that. The owner knows that.
Okay.
Did that answer?
Can I mention something I think that was also in your question is, so Annette was talking about what licenses can transfer or not, irregardless of the overlay, if there's an overlay or not. But the difference with the overlays, and I think you were saying in the RO2, would that not transfer? The licenses can transfer, rental licenses can transfer, except for the ones that Annette mentioned that cannot. Generally, a rental license can transfer at the sale. The difference is that in the RO2, if there's no rental license already on the house, if an RO2 has been adopted in that district, the owner that owns that house in an RO2 can still apply for a Class 1 rental license at that time. But when they sell, the right to apply for that license would be gone. So the new owner would not have the right. But if they had an existing license that was transferable and they sell, that license will get transferred. The difference in the rental restriction overlay is that at RO2, the right to apply for a license does not transfer. So does that make sense? Okay, thanks.
Hello, I live in Glencairn, and this is about the overlay that is currently proposed. So some clarifications I would like to request, mostly for the city attorney. I understand that there was an original overlay proposed, and I've been told that the city attorney modified that. So I just want to know if it is true that you modified this overlay to what it is now proposed.
That is inaccurate. I've heard that a lot. I did not review. The process is that a map is proposed. I believe that was when Tim Dempsey was reviewing them, and he reviews them for compliance with subsection G, which is the one I referenced about ensuring that the district lines are composed of streets or edges of the subdivision or zoning district boundaries. And so, just like Landon and I recently did, we don't redraft the map, but what we would say, for example, is if there was a boundary that was between Clarendon and Saginaw, that was between residential lines, we would say that northern boundary is inconsistent with the requirement of the ordinance because you haven't used street lines or a zoning district boundary to make the northern boundary. Therefore, we would suggest to come into compliance, you would move it up to Saginaw you would move it down south to Clarendon, and that would fix that particular edge. We would do that on all 4 sides, but we ourselves would not redraft the ordinance. We would simply, the map. We would simply say ways to make it come into compliance with the requirements prior to it going to the Council and Planning Commission.
All right. So I'm particularly interested in what was redrawn on Oxford Road. So, and this is consistent with a previous question from the audience, from my neighbor. So I live on Oxford, and I was originally included in the overlay, but when the overlay was changed, I was excluded. So it's not just me and my neighbor, there's several of us who would like to be included. And so the question here is, who do we address to do this? So you're saying that this is not set on stone, right? This is not something that you arbitrarily decided according to what you just said. So who are the people to talk with if we want to include that part before this is approved or rejected?
Sure. So now that the circulator has provided us with a map that has been approved, there's 2 more review levels, both of which review input from the public. So the first will be at the Planning Commission, and the Planning Commission, one of their duties is specifically to determine if it would be better to increase or decrease the size of the overlay, and they will use public hearings to make that determination. So for example, if the people living on the north side of Oxford or the east side of Sabron came in a large number and said, yes, we all want to be included, then it may result in the Planning Commission saying, based upon the public hearing, we believe that it should be extended north to Saginaw, east to Abbott, for example. The second piece of that is after the Planning Commission, they then make a recommendation to Council. The City Council then reviews their recommendations and takes further public comment and input prior to making the ultimate determination. So it's only after both of those reviews that the final determination is made by Council. So your input, if you're not included and you want to be, or you're included and you don't want to be, is vital in both of those parts of the process.
So does it mean that I, as a neighborhood, can go around asking people for signatures? And if I have a list of signatures from my neighbors in that area, would that count? Is that appropriate?
It's more, I don't know if we've ever had public participation in that form. I think it's better if they come and provide their input to the Planning Commission and the City Council.
Okay.
I think it's helpful. One of the reasons is because we heard tonight, because people will say, well, I didn't really mean to sign that.
Right.
So if you, and then if there's other neighbors who want to be included, probably just as best, if possible, if they can come, or to the public hearing, or at all the public hearings, every individual has the ability to also write specifically themselves and have that on the record, and that would be probably the second best way.
So the problem is not only that they didn't mean to sign, is that it was not clear for many people what they were signing. Well, yeah, so they didn't mean to sign, maybe. They didn't know the consequences of the overlay as it is stated now. Like someone who is included, but across the street the people are not included, that's going to have consequences for the person who is in the overlay as well. So they didn't know that this was going to be the case. It was not clear where the overlay went through for them. They just signed because they thought, well, we're included. They didn't know that the one across the street was not included. So, okay, all right. So what you're asking is that these people who want to be included need to participate, need to be present. Okay, but of course there needs to be a way of engaging them, so I guess. That's it, thank you.
Thank you.
Good evening. Beverly Bonning, 601 North Lawn. First, I wanted to thank you for putting together the presentation tonight, given the significant impact of loss of staff in the city of East Lansing. I know that your time is valuable, and I thought it was a very informative presentation, and I appreciate the expertise involved in that. So thank you. I think all of us appreciate your efforts in that regard. I have two questions, and it's not related to the overlay district. I live in an overlay district, but directly across the street from me, Roxburgh is not in an overlay district. But my question has to do with rental license applications. I've looked at some of the criteria for a rental license application, and it seems pretty objective. And my question is, in its review and final approval by the governing body, is that approval discretionary or is it ministerial in nature? That's my first question. I think that's important to those of us who support the overlay district, and whether there is any discretion at the governing body level to not approve a rental license if it meets the objective criteria. And lastly, my second question, I'm not looking for an answer tonight, but I would appreciate some feedback on that at a later point. And my second question, I vaguely recall reading somewhere in the rental application materials about deed restrictions. And I'm curious as to whether the staff checks deeds when rental applications are submitted, or do you rely upon the property owner, for that verification? Those are my two questions. Thank you.
Yeah, so as it relates to whether it's a ministerial or discretionary review, I guess I'd have to say it depends, because there are some that are very black letter. It's a yes or no, but if it's a type of license that requires a family plus one, for example, you then go back to the definition of a family, and if I say that I'm in a domestic unit and I give the explanation of what my domestic unit is, there necessarily has to be some discretion in determining whether that definition has been met, and to that extent, we typically, it would be the three of us or the four of us and any other necessary input, from city staff.
And I can add, as far as the process when someone fills out an application and how are those reviewed. So there are review standards that are in our ordinance, and the Housing Commission. So once someone applies for a rental license, what happens so quickly, I'll tell you. So they fill out the application. With the application, there is a fee. There's also, we have a floor plan, a site plan, the photos of the exterior of the house showing the parking, because we do want to confirm there's adequate parking meeting the zoning code requirements in any given case. So they turn all that in. We review that application, make sure they're the owner of the property, et cetera, and there's an inspection. So our inspectors go out, do the inspection. The inspection is, we use the International Property Maintenance Code. Anything that needs to be brought up to code, the owner receives a letter and they need to correct those items and bring the property up to code compliance. If it's in their power, right? So we're in the middle of winter, so there are some exceptions to that. So if they have peeling paint, for example, some sort of exterior concrete work, maybe on a stairway or something, driveway, they're not going to do that right now. So then we do make allowances for that, but the license will, if issued, would be conditional upon them completing that work at a date that the Housing Commission and then the City Council approves. So once they get all their application and do the inspection, have a re-inspection if there are violations, are found to be code compliant at that time for all the items that they can correct. At that point in time, then the property is ready to go before the Housing Commission for a public hearing. Everyone within 300 feet of that property receives a notice of a public hearing, that there's going to be a public hearing for the initial rental license for that property at the Housing Commission. So neighbors can come, speak to the property, share their knowledge of anything related to that property. The Housing Commission does go through the review standards. As staff, we go through the review standards, and on our staff report, we answer every one of the review standards to say if, by our review, if they have met those review standards or not. Of course, the reason for the public hearing is every so often, someone knows something that we cannot confirm, and that comes up part of the public hearing process. So then if all those review standards are met, then the Housing Commission will make a recommendation to City Council to grant the license. Grant the license with conditions. There are some conditions that can be placed. So, maybe there's a request for an additional inspection having to do with landscaping because it's the middle of winter and we have no idea what's under this thick layer of snow and ice, right? So there may be some requirements for that. So, but the conditions have to be based on something. So they just can't be, well, we feel like the city should do extra inspections just because. That is not something that we can do. So legally, they have to meet all those conditions. Then goes to the City Council, and City Council then is the authority, the legal authority that can issue that license, or deny the license, or change the conditions. So that's.
Annette, can you answer whether or not you look for deed restrictions?
Yes, we do. So does staff look for deed restrictions? Yes. So we try to keep as many of those on file, and what we do is we record them right in our electronic records for those properties, so it'll be noted if they are deed restricted. We do rely on owners, of course, to let us know. So, if we miss something, if there's been something on file, it should come through. Do we check with the county every time? No, we don't. So I will say I don't check with the county every single time to see if the property is deed restricted. What I will say is the deed restrictions most commonly are due to some sort of usually financial funding through federal government grants, et cetera, and we typically have those on file. So we'll have that information. We put when the deed restrictions expire, if they do. I think there's maybe 1 or 2 properties in the city that an owner has just deed restricted for various reasons. And then the others, it might be owners have decided to deed restrict the property in lieu of some sort of fines or citations, and we would have those on file. So that is how we take a look at those.
Thank you. Sir, you're.
This one's short. I'm John Munn. Again, thank you for this evening. I've kind of watched this go back and forth. I've been a realtor here for 39 years. So a lot of changes since the early 80s. But a couple things I didn't catch. On sabbatical or house sitting, is there a limit as to how many can sit in the house? I didn't hear that mentioned.
Yes. So for house sitting, you are limited to 2 unrelated persons or a family.
Okay. And then also, when you're doing that, are the all trades inspections required for that as a safety factor or not?
There are no inspections involved
Okay.
with house sitting exception.
All right, thank you.
My understanding has been that there are no short-term rentals allowed in the city of East Lansing, with the exception of when somebody is rented for like a year and then it's month to month after that. Is that correct, or are short-term rentals allowed?
That is not correct, is the way I understand your question.
Okay, so Airbnbs are legal if they go through the rental license process?
So our rental licenses do not have, dictate a length of time of lease.
Okay.
The only time that does happen, and this may be where your question came from, is when we are reviewing an initial rental license for a property that is in a condominium project. So that can be a site condominium, so it just looks like a home when you're going to site condominium, or even a condominium in a multi-unit building. Part of the application process is that the owners have to submit the bylaws of the condominium association and portions of the master deed, anything relating to renting rules in that condominium association. There's some other things they have to do, but that's a part of it. So in those cases, in most condominium projects in the city, they do have some requirements, and we make that a part of the licensing rules also. In most cases, it will be that leases have to be a minimum of a certain time period. What I've observed is most leases have to be a minimum of 1 year, and there might be one condominium project that's 2 years. I'm not 100% sure. But we do have them submit the bylaws so that we know, because I don't keep up on everyone's bylaws either as they're changing. So that is part of the application process, and then there is.
And to do Airbnb, including at your own home, you have to have a rental license, correct?
Yes.
Okay. Sorry, go ahead.
I will say yes, except. So if I own my home and I live there all by myself, just me, and I want to have someone come and stay there, live there, et cetera, and again, we don't get involved in is there rent, no rent, because any two unrelated persons is considered family.
Okay.
And that's an exception. I can have one person come, and they could come and go. I mean, there would be nothing that triggered a license. So I do know of a couple cases where folks do short-term rent, per se, and that is they do it as a single person living in their home. One example I'll give is one person, they have a pipeline, I think, to some sort of visiting nurse, and the short-term guest usually is about 6 months, sometimes a year. But, and so that is how this person utilizes that. So we've seen it, we question it, we investigate it, and that's what we found.
And they don't need a rental license for that?
No.
And you don't investigate whether or not they really are a family, correct?
The two unrelated persons.
So two unrelated don't have to fit the city's definition of a family, but three unrelated, then two people have to fit the definition of the family.
You have to reword that for me.
So you were saying earlier that the definition of a family unit is people basically intending to be permanent, et cetera, et cetera.
Domestic unit?
Yes. So when you have a boarder and they're paying you, that's legal, even if you don't have a rental license, is what you're saying.
If I own my home by myself, no one else lives with me, and I'm having one other person live with me, that will not trigger the need for a rental license.
So if you're a single individual, you can have a boarder.
Correct. As long as you own and occupy the home. I can't leave. I mean, I can go on vacation, but I can't leave. I can't go live somewhere else.
So a family can't have a boarder, but a person who happens to be single is allowed to have a boarder?
You are right.
That's odd. And then just one more quick comment, and that is, you know, so much of what people are afraid of from rentals has to do with things that could be enforced by the city. And in Oakwood, enforcement went up over the last few years, and it really improved things. So codes started writing more tickets for party litter and party noise. The police started writing more tickets for party noise. Just a comment that some of what we're afraid of is actually manageable through enforcement, and the city sometimes does that and sometimes doesn't, and lately has been doing it in our neighborhood, and it's made a difference. The sophomores on policy has also made a huge difference, but that's another topic altogether. Thank you.
And I would say Dr. Drager always brings up really good questions, but she gets right to the finite issues. And so on those type of things, I would always like, if you bring them up to us, a very specific example of your house and what you propose or intend to do with it, an analysis unique to your circumstances is going to be best before you proceed with that.
Good evening. Peter Dewan, 602 North Lawn. Thank you again for all of your time and your explanation. I feel a little bit neglect because I served on the Planning Commission and on the DDA and on the Zoning Board and on the Planning Commission at a time when all these rental overlays were going throughout the entire city. So you think I would be fairly knowledgeable on all the intricacies of the application of the rental overlays. I do have a question, and maybe it's more of an administrative question than it is a legal question. But with the expansion of a district or the expansion of a rental overlay, it appears to me that there would be some notice provided to the residents that were not part of the original presentation to the city. Am I correct in that? Would there be a note, like, say, if the Planning Commission hears a collection of citizens that feel that they want to expand the overlay itself, then that would be presented to the council. Wouldn't there be some notice sent to residents that would be impacted by the extension of a rental overlay as far as notice of the city council meeting, because it could possibly impact their property?
That is not required by the city ordinance.
There would be a public hearing notice.
That's what I'm saying. They would receive a notice that their parcel is under consideration to be included in an expansion.
So when they come, Landon will help, when they,
Yeah.
so when there's an ordinance introduced at the planning commission and a public hearing held, you notify everybody.
Yeah, so our practice in accordance with state law is that if there's a proposal on a certain piece of property, we'll send public notice to everyone within 300 feet. So for the Glencairn neighborhood, for example, we took that boundary that was proposed and then vetted and approved by the city attorney, and we sent a notice to everyone within that boundary, and then within 300 feet outside of the entire perimeter. So they would be getting a public notice. It may not say, for consideration of whether or not your property would be added or subtracted. It would be a public hearing by the city council just to consider the district or the adoption of the district. Whether or not the boundaries would change would happen at that meeting.
Right, okay.
But without additional notice.
Thank you. And then for clarification with regard to the pending overlay, when is the planning commission meeting?
So the current pending overlay or request in Glencairn, the planning commission had their public hearing last week, and they'll have their next consideration next Wednesday, the 24th.
Okay.
7 p.m. is when the commission meeting starts. I don't know exactly when on the agenda this will come up, but they'll consider that at that time whether or not what kind of recommendation to council they would make.
Thank you.
Sure. Thank you.
Hi. Thank you for being here. Jeff Lipinski, I live on North Lawn. Looking at 2E, and tell me if I'm reading this wrong, but the city council could change the boundaries of an overlay district without regard to the 2/3 majority requirement.
As so far as they're increasing it, that's correct. Sub F does require if it's decreased, the 2/3 the 2/3 requirement is still met.
So they can increase it without regard to the 2/3. If they decrease it, they still have to have that 2/3 majority.
It's the 2/3 majority in the decreased area.
In the decreased area.
So the number could change, but they still must have 2/3 in the smaller area.
Okay. But the increase, that doesn't matter.
That requirement is not present in the
All right.
circumstance of an increase.
And they can't, and the city council cannot change from an RRO1 to an RRO2 or an RRO3. They just consider what was presented in front of them as far as the RRO designation.
As far as the overlay type of designation,
Yeah.
that is correct. They cannot amend that.
Okay. Thank you.
Any other questions? If not, thank you very much for joining us. If you have follow-up questions or something comes to mind later, please email Landon or Annette